Right. Always the start of a webinar is slightly odd because we never quite know whether it's worked, but I'm assuming it has worked. Those of you who are currently logged in, you will have a public space and a private space. Therefore, you can chat and provide questions if you want to give us questions. Obviously, you want to tell us what you got for dinner. Then if you put it on the public space, everyone else will know. Put it on the private space, then just we'll know. And in addition, hopefully, when I press this button, hopefully, a warranty will appear on the bottom of your page. So if you haven't, or you weren't part of the group I sent it to this morning, or if you haven't downloaded the warranty, you might want to do that because a lot of what we're talking about does refer back to a particular warranty and sort of discuss some of the clauses in that warranty. So it will be more helpful for you if you've got that. I think most people will have been sent that already. That's the intro. I haven't actually told you who I am yet. So this is a webinar by Archer. If I click on to this slide, I can do this. Archer was formed just under a year ago with 6 specialist construction lawyers who were all previously at another firm. We've set up this firm and we specialise just in construction law. You can probably work out where the name comes from if you look at the coloured letters on the slide. Today you have the benefit of me, unfortunately for some of you. I'm the senior partner, but that's just because they thought they needed to give me a title because I had grey hair. I also have 2 relatively new recruits to Archer, so Sarah Lester, who's a senior associate, and Sophie Bennett, a paralegal. Delighted to welcome them here. Sarah does not have a bigger head than anyone else. It's just that the particular photo we've got does seem to show that Sarah's much closer to the camera. This is a talk about collateral warranties, which we accept can be quite dull, but there are duller things in the world. So this is a bit like have I got news for you? Which one of those 3 is incorrect? So firstly, I did used to be an engineer and I like to tell everyone. I am actually a member of the Dull Men's Club where we celebrate the ordinary, albeit I didn't purchase that myself. Someone thought it was really funny to purchase it for me, but I do not live in the village of Dullingham, despite what various people will tell you. That's my best attempt at a joke on a collateral warranty talk. What we're going to talk about is the whole concept of collateral warranties. Why are we giving collateral warranties? Why have we got to this stage? What sort of industry forms exist? And then we're going to spend quite a lot of time talking about key clauses in the collateral warranties, what you need to watch out for, what you should be looking for, and perhaps the more difficult bit, what is sometimes missing. And then off the back of that, we're just going to sort of pick up a couple of sort of separate points about third-party rights, collateral warranties, and whether you can adjudicate. The good news for those of you listening is that I won't be doing a huge amount of this. Sarah and Sophie will be doing this. So without further ado, I'm going to transfer you to Sarah, and hopefully we're sort of seamlessly, we're going to twist the laptop around and it goes in front of Sarah. So there we go.
Thank you, Andrew. Okay, so firstly, looking at what is a collateral warranty. Essentially, a collateral warranty is a mini contract that flows from another primary contract and benefits a party who's not one of the original parties to that primary contract, but who's got an interest in the works being carried out. So as an example, a main contractor might be required to provide a collateral warranty in relation to the building contract, but for the benefit of a person who buys the development from the original developer. The definition that you can see on the slide comes from the Swansea Stadium Management Company case. That was a claim for breach of contract for defective works, which was actually brought by the leaseholder and operator of the Liberty Stadium. It was brought against 2 parties. It was brought against the County of Swansea, who were the owner of the stadium and the employer under the original contract, and also against Interserve, who were the main contractor under the building contract. The claim by the management company was brought under a collateral warranty. The key issue was whether the claim under the warranty was time barred, and that was because the claim had been brought more than 12 years after practical completion under the building contract. And the argument was over whether the limitation applicable to the building contract was also applicable to the warranty, and whether in fact the warranty had expired. The warranty itself was silent on the issue. So Mrs. Justo Farrell decided that the claim, sadly for the management company and happily for Interserve, was time barred. And in that case, she confirmed that the key point about a collateral warranty is just that the clue is in the name. It's got to be collateral. That means that the collateral warranty has always got to be dependent on the underlying contract. In this case, the limitation period under the building contract had expired. So even though the warranty itself was undated, the limitation period for the warranty had also expired. And that is all about this sort of principle of equivalence. So the beneficiary of the warranty can only ever have equivalent rights as the original employer under the contract, but not greater rights. So the list set out on the slide here is a fairly typical list of parties that are involved in a construction project. There will, of course, be circumstances where this might change in very complicated or, of course, very straightforward projects. But even if the project is very straightforward, if there aren't any funders or there's not a forward purchaser or a tenant in place, collateral warranties are still likely to be required. This is because there are likely to be subcontractors with design liability and other consultants employed who the employer will want the ability to bring a direct claim against, usually in circumstances where the main contractor is insolvent. And they'll need a collateral warranty to be able to do this, and we'll speak a bit more about why that is a bit later on. Also, the contracts normally entered into as a deed, so it has a limitation period of 12 years. So it will need to allow for any future changes. So if the development is later on sold or leased to a different tenant, those parties might need the benefit of a collateral warranty later on. So the contract needs to allow for those potential future changes. This slide shows a diagram of the usual setup of a construction project. I'm sure many of you listening will be very familiar with this. So the employer will initially appoint their professional consultants. That can be for the design elements, so the architect, structural engineer, and so on. And also for the non-design elements, so for their contract administrator, project management, that kind of thing. There might be a funder in place. There might be a funding agreement for a funder providing some finance in relation to the project. There could be forward purchases. There might be a sale agreement in place, and there might be a tenant lined up, so there'll be an agreement for lease in place. So each of these agreements will include obligations that will need to feed into the building contract. The contractor is then, of course, appointed, and they in turn will appoint their subcontractors, and they might also appoint some subconsultants, or the original consultants might be novated to the contractor from the employer. Not all of these parties will have a contractual link between one another, and we'll come on to why that's important and what relevance that has to warranties. So just a refresher of the basic law. The general law in relation to contracts is that the parties to a contract have privity of contract, and that really means that the two parties to the contract are able to sue one another, but nobody outside of those two parties. There's also the law of negligence, which doesn't require a contract. What is important for claim and negligence is that there's a duty of care owed by one party to another, and that allows the party who's owed the duty to sue the other where that duty has been breached and where a breach has caused a party a loss. So sensibly, you might think that in the absence of a collateral warranty, the law of negligence can step in, but unfortunately that isn't the case. So the reason why negligence can't be relied on is probably best explained by reference to an example. So if we took a car accident, so if I drove into your car, which unfortunately with my driving skills is quite likely, and I were to cause damage to your car, you can bring a claim against me for the damage caused. And that's not because we have a contract in place between one another. It's because I owe you and all of the other road users a duty of care. And by driving my car badly, I've breached that duty and caused you a loss. So construction, you might think, should be exactly the same. If I'm a building contractor and I build a building and subsequently you move into that building and my bad building skills cause you a loss, surely you should be able to bring a claim against me for breach of a duty of care. The reason you can't is basically because case law tells us that you can't, and as the slide says, it is a bit of a fudge. So there are two key cases, which are the ones up on the slide, Anne's and Merton London Borough Council and Murphy and Brentwood Borough Council. Both of these cases went all the way up to the House of Lords, so both important decisions, and both were claims against councils and were in relation to how they had exercised their role as building control inspectors. They actually both have quite similar facts as well. So in Anne's, which is the earlier case from 1978, it was a claim brought by tenants of a block of flats. Those flats had suffered structural defects because there were inadequate foundation depths, and those depths have been inspected and signed off by the London Borough Council as building control. In that case, the House of Lords decided that the council did in fact owe a duty of care to the tenants to ensure that the foundations were at the correct depth, and that allowed the tenants to bring a claim in negligence. So happy days. However, in 1991, there was another case also going all the way to the House of Lords, and this was the Murphy case. And in that case, the House of Lords explicitly overruled the outcome in Anne's, which is quite unusual. As I said a moment ago, it's really similar. This was the purchases of a house. Again, it was a problem with the foundations. Those purchasers suffered losses because they couldn't actually afford to carry out the remedial works, and ultimately they had to sell their house at a loss. They brought a claim against the council as they were building control and they had signed off the construction of the house. But the House of Lords came to a different conclusion and actually overturned the earlier decision. And the reason for that, it was because it was a bad decision, because it opened up the floodgates to wide liability claims for what the court decided was pure economic loss. So basically, the council couldn't be liable for negligence, where the defects hadn't actually caused physical injury, had only caused these pure economic losses. Essentially, this was a policy decision because the court felt quite uncomfortable about allowing multiple claims against councils. But it effectively means that in relation to construction, any claim in negligence is very, very unlikely to succeed because nearly all claims will be categorised as pure economic loss. For the mega geeks amongst us, including myself, the reason that the House of Lords were able to overturn that earlier Anne's decision was because there were 5 law lords sitting in that decision and 7 sitting in the later Murphy case. It's almost like they'd planned it that way. So this cued the rise of the collateral warranty, and that was to address the issue of privity of contract and also the inability to bring a claim in negligence by creating a contractual link between the third party and those responsible for designing and constructing the works. So again, going back to the diagram of the sort of usual setup of a construction project, we've now added some broken lines which show all of the potential collateral warranties that might be required between the various parties. And as this diagram shows, they can be numerous, even in a fairly straightforward contract. As I'm sure lots of you have got experience of, negotiating and obtaining collateral warranties from various different parties can be a really time-consuming business. So the amount of sort of time and work that can be involved shouldn't ever be underestimated. So just a few key points. Really, the one key point to remember about a collateral warranty is that they are collateral. They can only ever be as good as the underlying contract or appointment, depending on who's providing the warranty. And they're always going to be limited by that contract or appointment. The courts have repeatedly held that a warrantor can be no more liable under a collateral warranty than they are under the original underlying contract or appointment, this sort of idea of equivalence. So as the beneficiary of a warranty, you really do need to ensure that the underlying contract or appointment is provided along with the collateral warranty, because you need to know what it is that you're actually getting the benefit of. Okay, so having considered the general principles and the sort of general law behind collateral warranties, we're now going to have a look at the various forms of collateral warranty that are available in the market. So there are some standard forms of warranty. JCT and the Construction Industry Council both produce standard form warranties. BPF, the British Property Federation, have produced warranties, but this was last updated in 2005. And we don't tend to come across any other standard forms. There might be some out there, but if they're used, they're very rarely used. Even where standard form contracts are being used, it's really typical for a bespoke form of collateral warranty to be included rather than use of one of the standard forms. So if a contractor is employed under a JCT design and build, for example, the collateral warranties included do tend to be bespoke. The reason for this is that standard form warranties are generally not accepted by all beneficiaries or most beneficiaries. They tend to, the standard form warranties tend to have really strict limitations, which the market standard bespoke forms don't. This is probably because they're drafted by industry bodies. So the JCT warranties tend to be very contractor friendly. The CIC warranties are very consultant friendly. Generally speaking, if there's a funder involved, which there very often is, it's the funder who dictates the nature of the warranty, and they generally do require bespoke warranties. There's also issues with the use of the standard warranties in that they don't provide a full suite. So the JCT suite doesn't include a consultant warranty, and the CIC suite doesn't include a contractor warranty. So if standard warranties are being relied on, there isn't really the ability to have consistency across all of the warranties, which is usually not acceptable to employers. So in most circumstances, it's a bespoke form of collateral warranty that's going to be required. So bearing that in mind, we're going to spend some time looking at a typical bespoke collateral warranty. To help with this, and because it's generally easier to have a bit of an example, we've sent out a typical bespoke collateral warranty, which we're going to use as the discussion point, as Andrew mentioned earlier. So we're going to use this to reference the usual terms and what to look out for with those terms. The example warranty is based on a warranty to be provided by a contractor, probably for the benefit of a funder, but the clauses we discuss will apply equally to warranties provided by consultants or subcontractors and for the benefit of other parties. The first clause that we're going to look at is clause 2.1, which deals with the contractor's obligations. Sorry, just need to look at the chat.
Yeah.
So we're going to look at clause 2.1, which deals with the contractor's obligations under the warranty. So clause 2.1 of the example warranty includes the necessary clause that sets out what the party providing the warranty, so in this case the contractor, is warranting. This clause is really typical of an industry standard bespoke warranty. It confirms that the contractor has complied with their obligations under the underlying contract, what their design liability is, confirmation that they haven't used deleterious materials, and confirmation of compliance with performance specs, and in this case that the works will be fit for purpose. We'll discuss each of these points in greater detail in a few moments, but first and foremost, it's really important if you are providing the warranty to check that these obligations don't exceed the ones that you've given under your underlying contract or subcontract or appointment. The design standard is dealt with at clause 2.1b of the example warranty. The key words really to be aware of in relation to the design standard are the words "with all the skill, care and diligence to be expected of a qualified and experienced design and build contractor." Now, whilst that might sound perfectly reasonable if you're a design and build contractor, there is an issue with this wording, that the wording should in fact relate to a professional designer. The reason being, in the absence of any wording to the contrary, the implied standard of care for a contractor is fitness for purpose, as opposed to a designer, which is reasonable skill and care. This is really quite an odd rule, and it comes from a decision in the IBA and EMI and BICC case. In that case, the proceedings related to the construction of a TV mast on Emily Moor. As a result of high winds and ice, something called vortex shredding occurred, and that resulted in the mast collapsing. At the time, the contractor, who was EMI, had appointed BICC to carry out the design, but there was no express reference to the nature of the duty of care for EMI towards the employer, which was IBA. In this case, the court distinguished between a contractor's level of skill and care as opposed to that of a designer, and the court were effectively saying that in the absence of any contrary wording, a contractor guarantees that the finished product is fit for purpose, and this includes their obligation for design. In practice, what has emerged is really a quite bizarre situation where a contractor owes a duty of care for design that's higher than that of a designer. And this is why it's important that any reference to the standard of care for design is that of a designer and not a contractor. This can be seen in both the NEC and the JCT standard form contracts, which refer to this reasonable skill and care to be expected of an architect or a designer, even though they are, of course, contracts for contractors. And this is effectively to prevent the issue arising that arose in this case, IBA and EMI. So clause 2.1e, moving on to fitness for purpose of our example warranty, includes an express fitness for purpose clause. And we'll talk a little bit more about why these are such an issue shortly. I would say that probably most contractors and subcontractors and consultants, or at least their PI insurers, are very aware of the issues with express fitness for purpose clauses. So the ones that often catch us out are the potentially implied fitness for purpose obligations. And they're difficult because they can be quite difficult to spot. Clause 2.1d is a good example of an implied fitness for purpose clause. This was highlighted in the case of MT Hogard, which I'm sure lots of you have heard of. The claim was in relation to the Robin Rig wind farm. Unfortunately, the grouting to the foundations failed. And whilst it was accepted that the design carried out at the time was to recognise standards, the contractor had exercised reasonable skill and care, it turned out that the standard was in fact incorrect. The cost of the repair was £23.6 million, so really quite important for both parties. In the contract, there were conflicting clauses. One said that the contractor was to use reasonable skill and care, which they, of course, did exercise. But there was a provision tucked away in a performance specification, which formed part of the contract document, saying that the foundations would have to have a design life of 20 years, and that was seen as a fitness for purpose obligation. The court were left with deciding what happens when there are conflicting terms, and they came to the conclusion that the higher standard applies, and this meant that Hogard, the contractor, was ordered to pay the £23.6 million, which I imagine for them felt like a very harsh decision, considering they had exercised their reasonable skill and care. So that's why it's so important to be aware of this wording around performance specs. Because if you have any of these competing clauses in your contract, it is likely that anything that could be conceived to be fitness for purpose will apply. So why does this all matter? Well, simply speaking, if you sign up for a fitness for purpose clause for design, it's really likely that you're not going to be covered by your PI insurances. Which means in the event of a claim, you are going to be left paying for it. So on the slide, there's an extract from a typical insurance policy, a PI policy. You can see that the exclusions refer to you not being protected for a fitness for purpose obligations. Now, insurers, doing what they do best as insurers, will argue that this means that you're uninsured, full stop, not just up to the level of reasonable skill and care. So it is really important to be aware of these fitness for purpose obligations. Moving on to clause 2.2 of the example warranty. Now, this is the limitation clause. It sets out the usual limitation that the party providing the warranty owes no greater obligations to the beneficiary under the warranty than it owes to the employer under the underlying contract. In this case, obviously, could be subcontractor appointment, depending on who's providing the warranty. So linked to that sort of general limitation are two further limitations. So firstly, clause 2.2a, and that's that the warrantor may rely on any limit of liability or other term of that underlying contract. And the next one is at clause 2.2b, and that's that the warrantor is allowed to raise equivalent rights of defence as those available to it under the underlying contract. So these are all fairly typical, but there are some things that are missing from these clauses to what we would usually expect to see. So firstly, looking at the limitation clause at 2.2a of your warranty. This is fairly typical, what's there. What isn't there is an express clause dealing with the limitation period that's applicable to the collateral warranty. Now, the limitation period essentially has to mirror the underlying contract, which, if entered into as a deed, which is usually the case, will be 12 years from practical completion. If it's not entered into as a deed, if it's underhand, it will be 6 years. The collateral warranty needs to reflect this. Under this example warranty, the limitation period is dealt with, but it's dealt with separately at clause 10. And if you have a look at that clause, you will note that the liability period runs from making of defects rather than practical completion of the works. That is quite unusual. it's very unusual for a limitation period not to run from practical completion under a building contract or a subcontract or an appointment. And any potential extension to that needs to be very carefully considered if you are the party providing the warranty, because it essentially extends the period of time that you will be liable for. The other thing that's missing from this warranty is that, in this case, the contractor has no liability for delay to completion of the works. Now, while a collateral warranty is generally relied on in relation to a claim for defective works, there isn't a reason why it couldn't be relied on by a funder, for example, who's suffered loss as a result of delay. This therefore really should be expressly dealt with, particularly if you're the party providing the warranty. Okay. The equivalent rights of defence clause is at 2.2b. The wording that's missing from this clause is the wording that's in bold on the slide, as it would have had if the beneficiary had been named as a joint employer with the employer. Now, this is an important consideration, but for the beneficiary this time, because this prevents the contractor, using the example warranty, from raising a no-loss defence on the basis that the original employer hasn't suffered a loss or has suffered a loss that's different to the beneficiary. The underlined wording is the usual carve-out in relation to set-offs and counterclaims against the employer under the underlying contract. Again, inclusion of this wording is important if you're the beneficiary of the warranty. This comes from the Safeway case. The High Court were asked to consider whether damages could be recovered from a contractor under a collateral warranty. Safeway had entered into a development agreement with the developer, who was Chelverton Properties Limited. It was for the construction of a new Safeway supermarket and a car park. The building contract was between Chelverton and their contractor, who was Interserve. And Safeway had the benefit of a collateral warranty. Defects occurred, and there were issues with the waterproof membrane on the car park, and Safeway sought to rely on their warranty to bring a claim against the contractor, against Interserve. The warranty contained a clause stating that Interserve would owe no duty or have any liability under the warranty that would be any greater or of longer duration than that which it owed to Chelverton under the building contract, so the typical limitation clause, but it didn't have this set-off wording in it. Interserve, the contractor, relied on this clause to argue that if a claim had been brought by the employer, Interserve wouldn't have been liable to pay damages because it had a set-off. The employer actually owed them just over £1.25 million. The court considered that the purpose of, it was clause 3.3 in their warranty, but that the purpose of that clause was clear. It meant that Interserve's liability to Safeway was restricted to its equivalent liability to Chelverton under the building contract. So the contractor's liability to pay damages for breach of contract for the defective car park was subject to Interserve's right of set-off. And that right of set-off amounted to a substantive defence to Safeway's claim, very unfortunately for Safeway. In summary, careful consideration of both design obligations, fitness for purpose, and the limitations applicable to a warranty really need to be of key consideration when reviewing collateral warranties. I'm now going to hand over to Sophie, who's going to look at some of the other key clauses in our example warranty.
Swivel the laptop again. Just take that. So the first ones that I want to take a quick look at are clauses 3 to 7 in the warranty we've given you, which are your step-in rights. So if you take a look at these clauses, first of all, what are step-in rights? What is a step-in clause? So this is just essentially a party stepping into the underlying contract during the life of the works. So after the life of the works, this clause is fairly useless. It's usually a funder that will step in the event that the employer goes insolvent, and this helps you guys get your projects done. So the main points to notice, they're very sweet, very simple, these step-in clauses. So all you need to make sure that you have in there really is a notice mechanism and the governing clauses on how we're going to get to that final position of step-in from A to B. The two key points that you really want to consider at this point in time are, one, how long do you give the party who can step in to exercise its step-in right? And two, will they have to pay monies before or during that step-in period? So usually in the case of insolvency, the answer is yes, that person stepping in will be paying any outstanding monies, which is great to everyone involved. So for step-in, what do you really need to look out for? So if you refer in your warranty to clause 3.1, there has the mention of suspension in here. However, this really shouldn't be in there, as the contractor will have a statutory right to suspend in the event of non-payment after a 7-day notice. So if this clause refers to suspension and gives 21 days notice, then the contractor will essentially be having to work without payment until the suspension bites, without any guarantee that the beneficiary exercising its step-in rights will actually step in. So if this only refers to termination, then at least the contractor can suspend the works in the meantime until the decision on whether to step in or not is made. It isn't common, though, to see reference to suspension in these step-in rights. You also want to check for whether there is an obligation on whoever is stepping in to pay anything that is unpaid or outstanding. So in this example warranty, if you check out clause 3.3C2, there is an obligation. So happy days. And there will usually always be a mechanism in your step-in rights for that person stepping in to pay any subsequent sums that are due because they have essentially become the employer. If you also take a look at clause 6, clause 6 is a little bit different. So this is talking about nominees. So if a nominee has been nominated by the beneficiary, you need to make sure that there is a guarantor in there or a guarantee. This is just in case that nominee doesn't have the money to actually pay what is owed or just doesn't pay. So step-in rights are great because you are more likely to get paid as a contractor or as a subcontractor in the event of insolvency of the employer if there is step-in rights available. So these are fantastic to have. So moving on, we're going to take a quick dive into copyright, which in your warranty is clause 8. So copyright really needs some perspective taken on it whenever you're looking at these clauses. These negotiations always become quite long and drawn out, but 99 out of 100 times it's not really going to be an issue in the event of a claim. So copyright clauses are probably not the hill to die on. What you do want to check for, though, in your copyright clauses are the key issues for scope of the license and what happens in the case of extensions. So first of all, what you'll need to do when you're considering these two issues is check your definitions. Go right back to the beginning of the contract, check your definitions. In this case, we have the definition of permitted uses. So what does this say? How far does it go? What is it letting these licenses cover? So in the warranty that you've got, you will notice that in the definitions of permitted uses, it actually mentions extensions, which means that it doesn't limit the scope of the license, so it can be used for any extension. However, later on, we will be sending you a warranty that is more correct, if you want to call it that. And you will see that what we have done is put in a clause 8.2, which does not allow the reproduction of designs contained in licenses in the event that there is an extension. So this prevents the kind of pay once for a design, but use twice. So it stops an identical building being built next door with those designs without paying the architect a second time. So that's really what you want to look out for there. You also want to check your wording to make sure that the license is irrevocable. So this is really quite key when you're looking at insurances, because a lot of insurances will be invalidated if licenses are subject to the payment of fees. So you want to make sure it's not subject to the payment of fees, it's not revocable. So if you take a look at the warranty that you have, not only is it missing sort of the carve out of extensions, there is actually something else missing. And it's something that's quite common. So in the warranty we will send around later, there will be a clause 8.4. And this clause means that the use of the licensed materials are only permitted for what the materials were prepared or provided for. So this just limits the risk. And as I said, there will be the limitation on those materials for extensions in the warranty we'll send around. So next up, we're just going to take a quick dive into the PI insurance clauses. I'm sure you guys have seen loads of these. So this is clause 9. So when you're looking at these clauses, check out the scope and the level of insurances that will expressly be written, or should expressly be written in clause 9. Make sure this matches what you hold or what you are offering in your project. You also want to make sure, and this is a very, very key point that Andrew will also be talking about later, is that you're not invalidating your insurance with clauses that aren't allowed. For example, here, clause 9.1c. You may hear this referred to as a normid clause. It comes from the Normid Housing Association case for, again, those mega nerds out there. So it's just important to check warranties and contracts with your insurers before you plunge straight in. And then simply 9.2, 9.3 and 9.4 are just saying, it's fine to accept that the other party cannot get insurance. But what is not fine is to let them start charging you for it, or the difference in cost, unless this is something that's negotiated. So we also just wanted to pay a quick visit to a very common question, which is the difference between each and every and aggregate insurances. So each and every insurances, as you will see up there, it basically means that you can claim the full limit of indemnity for every claim, regardless of the number of claims in the period of insurance. However, aggregate means that you can only claim up to that limit in any one period of insurance, which is usually a year. But it's not quite that simple, because there are also different ways of saying each and every or aggregate, which complicates the matter a little bit. So here we have 8 different expressions. If you take a look at them, 1 to 3 are each and every expressions, 4 to 6 are aggregate expressions. Number 7, when we start talking about reinstatements, this one's a little different. This one is actually an aggregate limit, which is reinstatement up to the limit of X. And 8 is an each and every limit that uses reinstatements, because they are unlimited reinstatements. So finally from me, we're going to take a quick look at clause 11, which is assignment. Again, it's quite sweet and simple. What we don't want to see in any wording is the word transfer, because it's not useful and it doesn't have a legal definition. We think it probably means novation, though there's not really been much case law around this, but it is very vague, so try and avoid it. So what's the difference between assignment and novation? Just a little quick recap. Assignment is the transfer of the benefit of a contract, but not the burden. So they don't have to pay you, but they get all the rights. And novation is the transfer of both the benefit and the burden of a contract. So if you take a quick look at clause 11, what you want to do when you're looking at warranties is check how many times you can assign. So the standard is twice, with the carve out of funders and group companies. But do check with your insurers, because some insurers do not allow unlimited assignment. So make sure you negotiate that in. The warranty that we've given you at the moment does not have a limit, but we will be sending around that more correct version later that has a limit of 2. And then finally, we just wanted to touch upon clause 11.3, which is essentially a no loss clause that was mentioned earlier, which basically means that the contractor cannot argue that the assignee cannot claim a loss because they didn't suffer the loss or they weren't party to the original agreement. So that's it from me. So I'm now going to pass straight back to Andrew for more insurance fun.
We're nearly there. And it's a pleasure to sit next to two people who are really good at doing presentations. Okay. So your insurance policy, when was the last time you've actually read it? More to the point, have you ever looked at it? Because it's quite important that you do, because there are certain requirements in your insurance policy that you are not allowed to have. And both Sophie and Sarah have talked about the issue of, you're not allowed to have situations where you have no wider rights, where you have an unlimited right of assignment. You can't have fitness for purpose clauses, and also, as Sophie has mentioned, you can't have, depending on your insurance policy, you aren't allowed to have normid clauses. So it's important that you actually read it, understand that the way you are entering into warranties complies with your insurance policy, because the last thing you want, and arguably also the beneficiary wants, is a party that doesn't have insurance backing the warranty. Not much more to look at other than perhaps after this talk you might go and have a look at it. What's the difference between collateral warranties and third-party rights? Well, not a huge amount, to be perfectly honest. I'll come on to what the Act is that introduced third-party rights, but they are essentially the same. If you look in the back of a JCT contract, they have third-party rights schedules. They're very similar in wording to that of a collateral warranty, but you have to be slightly careful. You can't just grant a third party all the rights under a contract, because if you did, you would be granting a funder the right to issue instructions, the right to terminate the contract, arguably the right to, change the specification. So you have to grant them a particular set of rights, and those rights are very similar to the rights you grant under a collateral warranty. So that's why you have third-party schedules with the rights in them, rather than just saying, you've got all the rights under the contract. The third-party rights were introduced by the Contracts Rights of Third Parties Act 1999, and one of the express points about that, as said in the legislation in the sort of parliamentary discussion, was to enable third parties effectively to get the rights without the need for a collateral warranty. However, it's one of the few pieces of legislation where you are entitled to contract out of. So what did the construction industry do? It introduced a clause in all their contracts immediately contracting out of it. So it's not been that widely used. Even 20 years later, that there's a limited uptake. There are certain brands, particularly hotel brands, who are producing quite a lot of similar schemes, who tend to use third-party rights. And on the bigger London schemes, maybe it's more common. There is a problem with, perhaps what's more common actually on the London schemes is an either-or, a collateral warranty or third-party rights. What the problem is that you can only grant rights that are within the contract itself. So a third party can't be given rights unless the contract itself enables that to happen. The problem is that if you don't have a copy of the subcontract, you can't be certain that the subcontractor granting third-party rights has got that right in their subcontract. So it becomes quite complicated when you're not in control of the particular contract. So what tends to happen in practice is third-party rights are given at contractor level and collateral warranties are given at subcontractor, subconsultant level. So until that wrinkle is fixed, I'm not sure we're going to see it take over. The one final point before we have some questions is, can you adjudicate under a collateral warranty? And the answer is, well, there's two cases, one saying you can, one saying you can't. It really does depend on what the wording says and when the warranty is given. So if it's given pre-practical completion and it has wording such as has carried out and shall carry out, it suggests that the warranty is for the carrying out of construction operations, as opposed to just warranting something that has already been carried out. So if you're giving the warranty during the life of the works rather than at the end of the works, then they are more likely to be adjudicatable than not. The truth is, people don't tend to adjudicate with warranties anyway, because warranties tend to relate to defects. And defects don't tend to be adjudicated. They tend to be the sort of claims that go to court. So in practice, it's all very interesting, but in truth, there are very few adjudications that take place under collateral warranties anyway. So hopefully at the end of that, you know a bit more about collateral warranties. We've sent you a warranty before we did the talk and during, which is, we sort of slightly tweaked one. We're going to send you one after this, which shows the track changes to show perhaps, as Sophie's explained, a more typical, fairer one. We have a bunch of questions, and at this point, I'm just going to put that here. We're going to move this so theoretically you can see all three of us, and we're going to shuffle in a little bit. That's not too awkward, which it probably is. And we have actually had some very sensible questions come in from some of you on here, no doubt. So I'm just going to start with one. Let's start with Sarah. There's a question that says, standard JCT includes Section 7 assignment, third-party rights, collateral warranties. These are always deleted by solicitors. Can you explain why and why we don't use default JCT?
Yeah, there's probably a few reasons, but the two principal reasons are that the unamended JCT contract assumes that the JCT collateral warranties will be used. And for the reasons that we discussed earlier, they're unlikely to be suitable to most, if not all, beneficiaries. Another reason in relation to collateral warranties is that the employer under the contract usually wants the ability to withhold all or at least a portion of payment in relation to collateral warranties that haven't been provided. That's not allowed for in the unamended JCT contract, and the reason that that's important to employers is because they've probably got very strict obligations in any funding agreement or agreement for lease to ensure the provision of collateral warranties. So they need some kind of security that those are going to be provided, and what better way than to stop paying people. Assignment, again, the unamended clause in the JCT is unlikely to be acceptable. It doesn't allow any assignment by either party without that party's consent. And as discussed earlier, the kind of industry standard position is at least two assignments without consent. And again, normally funders will demand at least that.
Sophie, we've had a question on net contribution clauses. We've not talked very much about net contribution clauses, but the question is, why does the net contribution clause still exist? A bit like a dodo, I suppose. I thought that was excluded by all insurers, was the question, but how would you answer?
Yeah, so it still exists because basically givers of warranties want it. They want their risk to be limited in the event others aren't around or others are insolvent. But the the facts of the matter is that whereas a lot of insurers don't accept it, there are several insurers that require it. So, for example, architects insured by the REN, some of those insurance policies actually require them to have a net contribution clause. So in that situation, it's far better to include a net contribution clause than not, because otherwise your architect's going to be completely uninsured.
Okay, I've got one. Someone said, will the new building reform bill, I think they mean building safety bill, impact on PI exclusions? And I think the straightforward answer, so the building safety bill relates to new buildings built over 18 metres and covers higher risk buildings. And the truth is it will invariably have an impact on PI exclusions. And in fact, it may be very difficult at all to get PI for those sort of buildings as when that legislation comes in. There is some discussion about the RIBA actually setting up, or the government setting up a PI almost policy that could be purchased from them for higher risk buildings. So in answer to that particular question, yes. And I suppose another couple of questions which we've had during the talk as well. What if a party refuses to execute a collateral warranty? Well, that's quite tricky. And that's one of the reasons third-party rights are quite helpful if you do have them. Strictly, if there is an obligation on someone to provide a collateral warranty, then on a strict interpretation, you could take them to court for specific performance. And the court could order them to sign the warranty if they had a strict obligation to provide it. That's not a 5-minute process, but ultimately that is the way you would get a warranty signed. We've had a question about what do you do if a contractor refuses to sign one. Well, the answer is your end game is to do that. It's not particularly quick, but if it's absolutely necessary, you can do that. Normally, I have to say, based on my limited experience of doing such things, because I haven't often had to threaten that, but when I have threatened that, they've signed it anyway, because the cost of an injunction to get them to sign it is pretty high. So often the party who's refusing to sign it will sign it. We've got one question that talks about whether professional indemnity insurance is a suitable alternative to collateral warranty. I'll just pass that over to Sarah, because I think I might be misunderstanding the point.
Yes, so a PI policy isn't really ever going to be a suitable alternative, essentially because they're two different things. So the collateral warranty is providing contractual rights between two parties that wouldn't otherwise have them. And the PI policy is providing an insurance in relation to breaches of a party's professional services. So usually that will be design liability. But of course, for the reasons we spoke about earlier, in the absence of a collateral warranty, that party isn't really going to be able to sue the other anyway. So you need both. You need the collateral warranty, and you need the person providing that collateral warranty to have suitable PI insurance in the event of a claim, so that there's money to pay the claim.
We had one question on the JCT form of warranties. I'm going to ask Sophie to answer this, which you don't have in front of you, but the question was, what does some of the limitation clauses refer to? So Sophie, I'll get you to answer that.
So this one was referring to the clause 1.1.1 and 1.1.2 in the JCT subcontractor's warranty, which is asking the difference, what construes as other losses under the JCT. So basically 1.1.1 is telling you that you are, whoever signed up to the warranty is going to be liable for any reasonable cost of repair, renewal and reinstatement. So, fixing up your damage. But 1.1.2 goes further than that, saying that they will be liable for any other losses incurred by the employer as well. So that basically just says that the employer can claim for anything or any other losses that you would be able to expect to be able to claim under a contract. So we would get this from the Hadley and Baxendale case that I'm sure everyone knows or hears in their dreams, as that states that losses that reasonably arise from the breach and were also within the parties' contemplation when they were contracting can be claimed as loss.
Right, it's come up to 12 o'clock. Time flies when you're having fun. Very briefly, someone has asked, as a demolition contractor, if you're just doing soft strip material and removing stuff, should you give a collateral warranty? The answer is no, because other than maybe from a step-in right, but it seems unlikely you'd need that anyway, so you shouldn't be giving a collateral warranty essentially for stuff you're taking away. And people have also asked, is this being recorded? And the answer is yes, it is recorded. I think there's almost an automatic email the day after saying if you really are if you're nearly as dull as me, you can actually watch the whole thing again. So it is being recorded. So if you someone said they want to pass it through to other staff members, so that's fine. It is being recorded as well. So thank you very much for that. Hopefully it wasn't as dull as it could have been. And that's us signing off, really. So we're going to stop the webinar, and thanks for taking part.
Thank you.
Thank you.